very well with a lot of alacrity.
My lord, the question which your lordship staff put to me was that I would, fully equip you with this. But can I know what level you are?
You should have said that I am at the Solicitor General's level.
No. But my answer was more honest. I said I am at KG level. He said, all right, then it would be easier for me to teach. That was a better thing.
Because then we have to find out, speaking for myself, teaching old horses new tricks. That they have to find out how difficult it is. But we are trying our best.
So we'll say, yes, it's work in progress for us as well. And I have to compliment Brother Justice Krishna Murari, who is, absolutely on the virtual platform with all of us.
Credit would go to my law clerks. They actually taught me. Whatever little I know.
So we'll say 509, 501, all the learned senior counsel appearing on behalf of the contesting parties, including the Solicitor General, are agreed that the hearing of this referred case be listed on 9 November 2022 at 10:30 a.m. The hearing shall proceed from day to day.
Lighter way, the Lord should be sitting in a different form.
That's the common
yes, right. The common compilation shall be filed.
Everybody has sufficient time.
The common compilation shall be filed by 1 November 2022. Who is acting as the one-stop window? Mr. Farasat and
Mr. Sadan and Mr. Padmesh Mishra.
Excellent. So that you both continue to do
The
that.
only thing would be, our judgment compilations may be different, which will file.
Okay. They are making a common compilation of the judgments as well. So you can share your judgments as well with the two learned counsels so that they can prepare a common soft copy compilation for all the judges.
Right.
And for all of
the bookmark?
We bookmark everything. Every document we bookmark the serial number.
That's right. And that will really make it very, very easy. And what we can do is if there are additional written submissions, then you can really include them in the written submissions folder so that any addition which happens along the way can be also marked and tracked.
Deeply obliged.
So now we'll take up 502.
Yes.
Yes.
502.
Because I don't know how your justice want to proceed with this. But if the matter is going to be heard as quickly as possible, and the matter is going to be decided, there is no need for any of this at this point in time.
Yeah,
that's what I feel. Because otherwise, we'll have to argue the whole matter unnecessarily.
It depends
on. Considering only IA. We have kept it.
IA means whether arguing the matter is
virtually
what would you like to do? All right.
May I respond, my lord?
Yes.
The same plea was taken on the last date. After hearing the parties, your lordships categorically said that today the two IAs which have been moved and because of which our contention is that the working of the EC is being stonewalled ought to be decided because there is no interim order prohibiting the EC to proceed. And our respectful submission for your lordship's kind consideration was that the main matter and the writ petitions which are pending have no bearing whatsoever on the exercise of jurisdiction by a coordinate constitutional authority under Article 324, which decides the larger issue of a split within a political party. And the nature of inquiry, the nature of powers vested is completely different from what the speaker will decide.
Now, Mr. Paul, if we have to hear the IA is by them seeking a stay.
Yes.
Roughly, what would be the timeline for the conclusion of the hearing?
The only thing I was responding to was because an impression is sought to be given to your lordships is that if this IA is held, then the whole matter might as well be heard, which is completely wrong. Because as far as this IA is concerned, the narrow scope is, and what they're seeking to confuse and deliberately intertwine is the larger issue of the powers of the speaker, which is a completely separate domain from the powers exercised by the EC. And the only basis of their saying so is that if a MLA is ultimately held to be disqualified, what is his locus to go and ask for and determine whether there's a split in a party or not? The disqualification or not of an MLA has no bearing whatsoever of a member of a political party to approach the EC for recognition of who represents the party and the symbol, because as your lordships and repeated judgments have held that a member against whom even disqualification is pending, he can even participate on the floor and vote. Even while a trust vote, a floor test, or any business of the house, he can vote. So a MLA against whom disqualification is pending can vote and participate. Can vote.
Mr. Sibal, would you like to open and give us a broad context? So maybe in about 10 or 15 minutes,
Yes,
once
sir.
you open, we'll be able to form a view as to whether we should conclude the IA today, or whether some of the issues which are involved in the IA are so intricately connected with the main reference that we should really then defer the IA for the main reference.
मैंने तो मेरा आपसे एक सवाल
Let's have a-
अगर मैं
let's
आपको
have
कह दूं
some
अगले
broad,
6 महीने के लिए
framework
कुछ नहीं
for the
करना,
argument
प्रोडक्शन में ध्यान नहीं देना, फाइनेंस में ध्यान नहीं देना, एम्प्लॉय पे ध्यान नहीं देना, सिर्फ 6 महीने बैठ के सेल्स करनी है। आप अपनी सेल्स कितनी बढ़ा दोगे? 1.5 गुना, 2 गुना, 4 गुना? सबके आंसर लगभग यही होंगे। और एज अ सी और एज बिजनेस कोच मैं गारंटी देता हूँ कि आप एकदम सही सोच रहे हैं, क्योंकि आपके प्रोडक्ट में दम है, सर्विस में दम है, आप बेचने जा रहे हो, आपकी पर्सनैलिटी में भी दम है, कस्टमर तैयार खड़ा है, आप उस तक पहुंचो तो सही। और ये बातें सिर्फ सुनने में अच्छी लगती है, क्योंकि हमारे पास तो वहाँ जाने का टाइम ही नहीं है। हम तो फंसे हुए हैं, कभी एम्प्लॉय की टेंशन में, कभी प्रोडक्शन में, कभी सीए में, कभी बैंक में, कभी उधारी में। हमारा जीवन तो एक सी सॉ के जैसे हो गया। जो बचपन में बच्चे नहीं खेलते थे, सेल्स पे ध्यान दिया तो भैया पूरा ऑफिस हवा में लटक गया, ऑफिस पे ध्यान दिया तो सेल्स हवा में लटक गई, और जैसे तैसे दोनों को मैनेज करे जा रहे हैं। और आपको लग रहा है कि ये
And one day
the impeachment application.
Sanjay.
Article 125 is the prayer. The application for that.
This one submission for your lordship's kind consideration. One of the other issues we had raised was that this prayer is beyond even the writ petition. They have not filed a substantive writ petition. In writ petitions pertaining to the powers of the speaker,
We'll hear you.
I thought I just
consider that.
Very
Yes, Mr. Sibal, are you open?
The lordship has seen the prayers at least 155.
533.
realize how difficult it is for us at this stage to start learning logic.
No, there's a little issue of the black hardware so much because the others are all here.
Also needs a cat.
Yeah, let me just
Yes, just give us a broad framework.
just broad framework for what the issue is the following. Kindly don't refer to any paper book. I just explained to you all. But this all started on the 20th of June, when in the course of the MLC elections, a seat that should have come to the Shiv Sena, we lost to the other party. That happened on the 20th of June. So on the 21st of June, the meeting was called of all the legislative members of the party. And many of them did not attend. And meantime, many of them had gone to Ahmedabad, and thereafter they went to Guwahati. So obviously, they're obviously not in tune or in alignment with the party itself. So we said that if you do not attend the meeting, there will be consequences. Now, this continued. They did several things between 21st of June. And ultimately they said that we said, okay, since you have not participated in these proceedings, we remove you. I won't go into the dates. I'm just broadly telling your Lordship Smith. And ultimately, they were removed from the post that they occupied in the Legislative Assembly itself. They in turn said that you are no longer a leader of the party. We have our own whip now. They appointed their own whip later. Those all things happened between 21st of June. And when ultimately, on the 29th we filed disqualification applications on the 29th of June, which is a very important day. No, hold on. On the 29th of June, which is a very important date. But on the 29th of June, they came here and they wanted to form a separate government in alignment with the BJP. And so, this court, we challenged all that, and this court passed an order on the 29th of June. Kindly note that. Between 21st and 29th of June, whatever happened, I'll tell you later. But 21st of June, it started, and on 29th of June, this court passed an important order saying, having given our thoughtful consideration to the diverse submissions, we do not find any ground to stay the convening of the special session of the Maharashtra Vidhan Sabha on the 30th of June. Tomorrow, that is 11 a.m., with the only agenda of a trust vote. The proceedings of the trust vote to be convened on the 30th of June shall be subject to the final outcome of the instant writ petition, as well as the writ petitions referred to above. So, what happened after the 29th of June in the assembly, the swearing in of the chief minister, the forming of the cabinet, functioning of the government, passing of the trust, everything, this court is subject to the outcome of these petitions. Which means the office of the chief minister is under a cloud. Which means what happened in the assembly is under a cloud. And that will be determined by your lordships when your lordships decide the petition. Then mark the third date, which is the most important date. It is the 19th of July, 2022. On the 19th of July 2022, Eknath Shinde alone moves the election commissioner. So, Malas, it is clear, therefore, that till the 19th of July, he had not moved the election commission. Everything prior to that was subject to the outcome of this petition. He is now submitting.
Mr. Sibal, when Mr. Shinde moves the election commission, in what capacity does he move the
We
election
have
commission?
put him out of the party. He has already given up membership of the party under the 10th schedule because
No,
of his qualifications.
when he moves, does he move in his capacity as an elected member of the legislature,
Yes.
or does he move in his capacity as a member of the party?
No, as a member of the legislature, he says that I am the party. This is the whole question, brothers. How will your lordship decide regarding the election matter, brothers, in the context of his moving the election commission and declare himself? You will have to first decide his status. That status will be.
Mr. Sibal, he can move only as a member of the party.
Party.
No, party under the
Yes.
schedule.
No.
Sadically, what your lordship has held is, brothers, that several layers. It has to be counted as to who is the party. And if he is disqualified as a member of the legislature, how will that layer be counted by the election commission? Legislative majority. This can't be done. Election commission can't go into matters, brothers, which are kindly said. The 1968 symbols order, brothers, happened in 1968, where in 1985. He says, herein, petitioner so and so, senior leader of the Sena Legislative Party and current Chief Minister of the state of Maharashtra, which is all under cloud by orders of this court on 29th of June. I challenge the very locus of the person, brothers, to move the election commission. The very locus is under challenge.
Which powers of the election commission are being invoked when he moved this application under 19,622? Is it under the symbols order or
Yes, simple.
or 10? It's on the symbols order.
Yes, it's under the symbols order.
So Sadiq Ali Naik.
Yes, Sadiq Ali. And Sadiq Ali was at a time when the 10th schedule was not there.
That's right. That's right. That's right.
And this is the very
That is
question
an
that
aspect.
the lordships have heard in the reference. That's the very question referred. Now, if you refer the very question, that means there's a prima facie issue to be decided. Now, my friend is
Mr.
asking.
Sibal, the mere fact that there is a reference which has been made does not stall a constitutional authority from taking recourse to its powers under the law.
But this is also.
Because you're right, that one of the issues which has been framed is the power of the EC to decide upon a split in a party.
Yes.
But that by itself and per se will not really restrain the authority from proceeding ahead if it has authority to decide that under the law.
I don't dispute that fact, but I'm saying prior to that, there are disqualification petitions.
So we got your point. Your point really is that on the 29th of June 2022, when this court passed an order, it made the trust vote was not stayed, but it said this would be subject to the outcome of the petitions.
That's right.
Therefore, according to the office of the CM, the proceedings in the assembly are all under really a cloud, or they are subject to the decision of the petition.
Correct.
And therefore, according to you, the proceedings before the ECI are an offshoot of what has happened before. Therefore, they shouldn't go on pending the disposal of the reference. That really is the sum and substance of your argument.
Broadly, that's what I want to submit to your Lord.
Yes.
Now, can kindly look at it this way. In the meantime, under the 10th schedule, they are members of the original political party. This is very important. 10th schedule does not recognize a split. It used to recognize a split, when Para 3 was there. But
Post 2003, para 3 go.
1st of January 2004, Manas, it was removed.
Original political party as legislators or as members.
Yes.
Legislators.
Correct. Therefore, Manas, the original
So
political
that's under question.
it used to recognize that it means he is a member of the original political party. But
Post 2003, para 3 go.
1st of January 2004, Manas, it was removed.
Original political party as
Now, if
legislators.
he is a member of the
or as
original
members.
political party,
Legislators.
correct? And there is an issue of disqualification that is pending. Whether it's pending or not, that's another issue. That again will have to be looked at. Then, whether if he is disqualified, having voluntarily given up membership of the party under 21A, and having violated the whip under 21B, this all happened prior to 19th of July, when he moved the Election Commission. And your Lordship knows, Mothers, in Rajendra Rana, your Lordships have held, the date of the decision will relate back to the act of disqualification. The day when that act took place. Now kindly have a look at the 10th schedule with me. Your Lordship knows, as a matter of law, that when any legislative party and members of the legislative party who are members of the House, the Speaker of the Assembly is conveyed those who are office bearers within the House, namely the whip. Who is the whip? That's conveyed to the Speaker. The whip, the chief whip, they continue to be members of the original political party while that whip is operating. They can't claim themselves to be a faction. But the 10th schedule doesn't recognize that. Election Commission does. The 10th schedule does not. So if you say that you are a separate faction while you are a member of the original political party, according to me, you have given up membership of the party. There's nothing more to be done. Because all of these are admitted documents. This is not evidence.
Therefore, Mr. Sibal, the position really is this, that the 10th schedule post 1/1/2004 does not recognize a faction, or the 1/3 split which it recognized prior to 1/1/2004 is now no longer recognized by the 10th schedule. On the other hand, you do have the 1968 order, the symbols order, which contemplates that there could be more than one faction of a political party. Now, the 1968 order governs a political party. The ambit of the disqualification provisions of the 10th schedule is the legislative party, the legislature party.
Right.
Because the speaker, in the course of his authority to decide whether there is a disqualification or otherwise, cannot let in evidence saliente to decide as to whether a group of persons are or are not members of the wider political unit called the political party.
No, it does. It does.
That is
218.
Can the speaker, for instance, we note from the written submissions, we are putting this to you because now we have the benefit of seeing the written submissions which have been formulated earlier. They say, for instance, that we have produced 1.5 lakh affidavits of members of the party saying that there is a faction which is represented by them. Now, does the speaker have the power to let in evidence to decide this process which would otherwise fall within the ambit of the EC?
No.
Now, therefore, we have to define, even for the purposes of your interim application, what is the ambit of the jurisdiction of the speaker on the one hand, and what is the ambit on the other hand of the jurisdiction of the election commission in terms of the symbol order? Because the political unit called the political party is a much wider configuration than the legislative unit of that party, which consists of the elected members.
I'm not arguing with us.
Now, does it dispute in regard to the former or the legislative party affect the authority of the election commission to decide the latter?
Yes.
That is really the heart of the matter that we have.
I will answer that immediately. But let's now see what.
Let's have a look at the 10th schedule. We'll bring
What
some
is the
clarity to our
jurisdiction of
thought
the speaker?
process.
Look at 2.1a.
2.1a, right?
First, let's see the definition. First, look at 1b, legislature parties. The definition of that. 1b. Legislature party in relation to a member of a house belonging to any political party in accordance with the provisions of paragraph 2. Paragraph 4 means, paragraph 3 is omitted if you notice. Means the group consisting of all the members of that house for the time being belonging to that party in accordance with the said provisions.
Member of the house is also.
Member of the house is very important. And it says, it uses the expression member of a house and member of that house on two occasions. So legislature party in relation to a member of a house.
Correct.
Belonging to any political party.
That political.
So it distinguishes it says any political party in the first part.
Yes.
So the definition distinguishes between a member of a house belonging to any political party.
Correct.
With the group consisting of all the members of that house for the time being belonging to that political
That's
party.
correct. So, Malad, if it is
And
Shiv
group
Sena,
of that house.
if it is Shiv Sena, it is Shiv Sena. If it's BJP, it's BJP. Because they have fought the election on a BJP symbol or a Shiv Sena symbol, and therefore they belong to that political party.
So we'll really have to then look at what is the ambit of the disqualification provisions and then contrast it or see if there's an overlap with the
That's right.
1968.
That's the exercise. That's why I said that if ultimately we have to decide all this, we are really going into.
So really the ambit in our eye is short. For according to you, one does spill over onto the other.
Yes.
You can't decide that as the election commission without having to comment on the disqualification, which is an issue pending before the Supreme.
Yes. This is the point.
That is the point.
Now, kindly see whether.
Now let's see 2.1a.
Yeah, no. First, see
Yeah.
the original political party, not 2.1a. 1C. Original political party in relation to a member of a house means the political party to which he belongs for the purposes of 2.1. So he belongs to the Shiv Sena. He is under the discipline of the Shiv Sena, under the control of the Shiv Sena, within the house. He has no other persona. Can't be a faction.
Being a member of the political party,
Yes,
he is a member of the house.
that's good.
So the relationship is with respect to his membership in the house.
With reference to the political party which set him up as a member.
That's it.
That's correct.
But the
So,
schedule,
in fact, Mullah, this is the first time in the Constitution that the term political party is used. Nowhere else in the Constitution
first time.
you find that expression. Now,
In fact, the classical books on constitutional jurisprudence in India all mention that the expression political party has not been defined anywhere at all.
actually, we know something
First
about
time it is in the symbols order, which predates 10th schedule.
Now, see Malas 2.1. Subject to the provisions of 4 and 5. Again, Malas 3 is missing. A member of a house belonging to any political party. Again, the word any is used. Shall be disqualified for being a member of the house if he has voluntarily given up membership of such political party, not the house. If you're asked, for example, I belong to one party, I've been elected on the symbol of that party. I go with a leader of another party to the governor and say, meet him and say, please call the house for the purposes of determining who has the majority. Just give you an example. That act alone will visit me with consequences under 2.1. Plus, your lordship must.
Yes, it was. Look at it from this angle. If there is a disciplinary proceeding against a member of a political party, if disciplinary proceedings against the member of a political party and the political party expels him, what is the bearing of that so far as his presence in the house? In Amar Singh, they said he sit only as an unattached member.
Yes,
So therefore, whatever happens in the political party will have no bearing on his position so far as the house is concerned. So he continues to sit as an MLA, but as an unattached member.
Yes.
So therefore, where does the convergence of symbols order and 10th schedule?
Well, that will not impact the symbols order at all.
No, I'm saying where does that will not impact.
Yes.
But political party's decision is not impacting 10th schedule. And his removal from the party.
Removal is not voluntary. This is the problem.
That's right.
Yeah.
But still his presence as a
But
MLA continues.
even if he's disassociated from the party, he doesn't have to follow the whip of the party because he's been thrown out. So he's not subject to any discipline of the party. Because lordship will appreciate that when I am thrown out of the party, it's not my voluntary act. I am thrown out by virtue of the fact that the party does not want me for any reason. But the party can proceed for disqualification against me, but they don't do that. So the speaker then says that because you've been thrown out and I've been informed by the whip of the party that you are thrown out, therefore I'll give you a separate seat and I'll call you an unattached member. Then I am not subject to the whip at all. But then 2.1 he will not come.
Ironically, expulsions are welcome because expulsion doesn't disqualify you. You sit separately, you are expelled. So that is welcome rather than to proceed against for disqualification.
No, the question is how it would, Mr. Simple, the question is how it would, the disqualification would have effect on the symbol order, deciding the dispute with respect to symbol.
No, but I am member of the original political party. I have been elected on that symbol. I continue to be under the discipline of that party, which are otherwise, it has just huge consequences. Any assembly any government can be thrown out. Any government can be thrown out in this fashion. What is the constitution meant? People go to the governor and throw out a government which is duly elected by the House, by the people of the country. Is this how the 10th schedule is to work? I have never heard in the democratic world that an elected government for a period of 5 years through these machinations is toppled. Why? Because we are discussing some academic issue about jurisdiction of the election commission. See the heart of the matter. Where is this democracy going? Any government can be thrown out. And then what happens is that you have your own speaker. He will not decide the petition, the disqualification petition. And you merely.
Now,
form the government.
now, Mr. Sibal, we have looked at the provisions of the 10th schedule. Could we now go to the powers of the EC? We'll so that we have to see the two sets of
that. Just allow me a little.
Yes.
So, therefore, 218 deals with giving up voluntary membership of the party. Yes. And 218 if he votes or abstains from voting in such house, contrary to any direction issued by the political party. So, I am the whip. The whip says you have to vote for the speaker, this candidate for the office of the speaker. They vote for a BJP candidate. Now, all this happens after 29th, which is all the subject matter of this court's order. Which he belongs or by any person or authority authorized by it in this behalf without obtaining in either case the prior permission of such political party, person or authority, and such voting or abstention has not been condoned by such political party, person or authority within 15 days from the date of such voting or abstention. So if somebody votes contrary, it can still be condoned by the political party. What it tells you is that the political party is in control. See the expression, condoned by such political party, not by a member of the House or the Whip. Well, that's kind of appreciate it this way. Legislative members of a political party function within the overall control of the political party. They are representatives of the people. They are not independent of that party. So the political party will then communicate to the chief whip, condone what he did. I mean, he didn't vote for us, doesn't matter. We don't want to take any action against him. Or he didn't come for voting, doesn't matter. It happens many a times. But there's an umbilical cord link between the member of the legislature and the political party. They're not separate issues. There are issues that your lordships will have to decide, which is what I said. Ultimately, those decisions will have to be taken by your lordships in the overall context. It can't possibly be, assuming whether your lordships were to, your lordships were to allow the election commission to go on, proceedings to go on. Some decision is taken. Let's assume that. Well, and in the meantime, these proceedings take place and he is disqualified. What's the consequence? These are issues of great moment for our democracy. Can we see, Malas? Explanation. This is also important. Explanation for the purposes of this subparagraph means an elected member of a house shall be deemed to belong to the political party, if any, by which he was set up as a candidate for election as such member. He can't say that I am a different faction now. He can't say that. Now, that's the next point I want to urge before your lordship is this. Any defense of a member of a legislature belonging to a political party for the purposes of protecting himself from disqualification can only be available under the 10th schedule and in no other form. If I move for disqualification, which I moved much earlier, he will have a defense under the 10th schedule. He came to seek a declaration. And his only defense under the 10th schedule is a murder. There is no other defense available under the 10th schedule. Now, it is the admitted position that there is no merger. So he has no defense. Till the 19th of July, when he went to the election commission, he has no defense. Now he wants to, what does he want to do? He wants to go to the election commission and say that I am the political party. But much before that, his acts and the legality of his acts as a member of the House and as a member of the political party are in question, which has to be decided in these proceedings. What he does is, he says that I am 40, 39 plus 1, Eknath Shinde plus 39. I am a majority in the legislative wing of the party. Therefore, I don't recognize it. What he's saying. That he can't do under the 10th schedule.
Yes, Mr.
No, it's one point. Now your lordship asked me, what is the relationship between this and the symbols order?
Right.
That's come.
Where is the symbols order?
Yes.
1868.
ये compilation भी होगा.
Now see the symbols order. Para 15.
Sure. Have you next it in your
Compilation of statutes.
It's in our written submission.
it's in your written submissions already? Yes, there's a compilation by the Election Commission. Murari bhai, आपको मिला?
Page आप 493.
हम थोड़ा उठेंगे ना ज्ञान.
Yes.
सुनो.
Compilation.
When we wake.
A compilation of statutes for us, rules and research materials.
Yes.
That has everything.
You got compilation of documents from the election commission also.
Sorry.
Yes.
But it's very
सुनो. iPad this.
Two of our convenience compilation. Compilation of documents and legal file.
Para 15 can be taken from several compilations.
Para 15 is there. Data in your written submission, para 3.2.
And also para 9, Lordship may kindly see. Para 9 at page 5.
It will remain the same. Change. Para 15 will remain the same in all these compilations.
Correct.
The gloss on para 15 may change depending on what you're reading.
Depends how you
But the
look at,
original.
how you read and how you look at.
That's correct.
No, actually, I have the copyright.
All right, we'll read paragraph 15.
Now see, when the commission is satisfied on information in its possession,
Some. 1 minute.
Commission is satisfied on information in its possession that there are rival sections or groups of a recognized political party, each of whom claims to be that party. The Commission may, after taking into account all the available facts and circumstances of the case, and hearing such representatives of the sections or groups and other persons as desired to be heard, decide that one such rival section or group or none of such rival sections or groups is that recognized political party, and the decision of the Commission shall be binding on all such rival sections or groups. So let me, see us put forth a situation where there is no dispute as far as the legislature is concerned. There are factions within the party, each of them claiming to be that party. And without any reference to what's happened in the House with it, they go to the Election Commission and say, we are approved. Election Commission can decide.
1 minute. So.
Now let's see at what point in time does paragraph 15 operate? On the date when he files this application, that is 19th of July. Correct, Mullah? Can't be before that. Even if the election commission were to decide, it could only decide on 19th of July when he moves the election commission. But as far as disqualification is concerned, it relates back to the date when he acted under the 10th schedule, contrary to either the whip or having given up membership of the party. So his status to move on the 19th of July will depend on your lordship's decision whether he stands disqualified or not, and he's voluntarily given up membership of the party. Voluntarily given up membership of the party, which is the decision of a constitutional authority, then how do we move the election commission? And the election commission has no jurisdiction to decide whether he is a member or not. Para 15 will operate when both sides agree that they are members of the party. It has to be that way. Because he's claiming that I belong to a rival faction within the party. And he's claiming majority within the party. So where is the question, Malaks, of paragraph 15 operating at all in this case? Therefore, Malaks, to say that paragraph 15 is operative and is independent of all this, Malaks, with the greatest respect, Malaks, is contrary to very scheme of the 10th schedule and the scheme of paragraph 15. Because paragraph 15 proceeds on the basis that you belong to the same political party and sections of a political party. If I have thrown you out, supposing I have thrown a person out, he can't move. He's voluntarily given up membership of the party. He can't move. And that's the decision of a constitutional authority. The election commission of India will decide much later. The question
is, Mr. Zibal, what's the next point now? We've got this part of this limb of your arguments here.
Yeah, so therefore, this is one part of it. Therefore, paragraph 15 doesn't come into play at all.
Right.
Now, let's look at it on basic principles. We are here because there's a prima facie case. Slowly, matter is pending. It is referred to a constitutional bench. Surely, the strong prima facie case, otherwise, it would not be sitting here. 2, what's the balance of convenience today? That so far the election commission has not proceeded and the matter is listed for hearing. And there is nothing that's happening. No election that's happening. In the Bombay High Court, there is a stay of the BMC election. Yes. Supreme Court.
Now, the stay on the elections to the BMC has come about as a result of which order?
Supreme Court.
The court, this court's order.
Supreme Court.
Not the Bombay High Court.
No, there is no stay at all.
There is no stay of PMC elections.
In one of the submissions I read yesterday, that they have said that there was a stay for a period of 5 weeks. That's what they have said.
When they produce the order, there is no stay.
The best of my knowledge. Hold on. There is no stay today.
The matter is coming up tomorrow in the High Court, and the state and Maharashtra Supreme before court number 2. State is asking for time for 2 weeks.
In the Bombay High Court?
Yeah.
Oh, yeah.
Yes.
That order is passed on 22nd August 22 in SLP number 19756 of 21. I can't understand why there is a chorus of
Dr. Singhvi, SLP?
SLP 19756 of 21 by your lordship's 22nd August 22, titled Rahul Ramesh Bagh versus State of Maharashtra.
And they have asked for 2 weeks' time.
But I beg your pardon, Manoj, that's the OBC reservation matter, nothing to do with it. My learned friends are thoroughly confused.
It's totally wrong. The last PMC elections, the state came out with an amendment that was specifically challenged by us for directed status for my learned friend is not appearing in that matter, so it doesn't.
No, I'm talking about the matter that's coming up in the High Court tomorrow.
As far as PMC elections are concerned, there is a status quo, my lord. That order we have placed, my lord, in our internal submission.
All right.
I'm just saying, Manoj,
That's for the balance of convenience. Sure.
But the matter tomorrow is about the OBC.
We'll hear you, Mr. Jagnani, we'll hear you. Let's follow some more. Yes. All right.
lot of enthusiasm all over. That's all right. Normally, the point is, what's the balance of convenience? So far, it has continued. Matter is going to be decided by your lordship's Manoj, and it will determine, all the issues will be determined.
All right. So prima facie case and balance of convenience.
And then, Manoj, irreparable injury.
Yes.
Do not decide this matter and allow the election commission to go on, and the election commission freezes the symbol. What's going to happen? It's irreparable injury. Was to be. Without determining the issues that are pending before this court. And if those issues are decided in my favor, and you allow the election commission to proceed, see the consequences of that.
Yes, Mr. Sibal, we've made a note of that. So, anything else, Mr. Sibal?
Don't take time without repetition. Very brief.
Who are you appearing for, Dr. Singhvi?
Well, there are 8 petitions. I am appearing for the
All right.
Yes. Parties, but who are on this side versus that side.
And you will be characteristically brief, Mr. Dr. Singhvi.
I'm grateful for the word characteristic. Correct. Your Lordship has always rendered me speechless before I started. May I be very pointed. Well, your Lordship has 4 points in the 10th schedule. The issue is narrow. Whether your Lordships on a...
Can you just formulate the 4 points?
Before I let me do that. Today, your Lordship is not hearing the matter.
Right.
Today, your Lordship is deciding the correct balance of convenience to endure till such time after Diwali, your Lordship hears the matter and renders judgment. That's the only issue today. Now, for that, far from being unrelated, as the other side is saying, the issue is in direct collision and inextricably intertwined. That's the first point. I'll be demonstrating that in a minute.
Just a moment.
Direct collision and inextricably intertwined.
Yes, Doctor.
Number 2, it is for that reason, and I'm not saying it's a judicial order, but it is for that reason that your Lordships has advisedly, in different combinations, from 4th of August 22, made it clear that people will seek adjournment in the election commission and the matter will not go on. There have been 3 dates in between from then to now, including one coming up later this week or next week. So it has been adjourned. That was the Lordship understanding. Of course, subject to the Lordship adjudication today, no doubt.
Tilda's application was heard.
Number 3, why this inextricable intertwining and collision was? There are 4 elements of the 10th schedule, which Mr. Simple has shown, but those need to be summarized. One is the phrase original political party.
Just a moment.
This phrase is very important. Political party, original political party. Now, I stopped at clause 4 of the 10th schedule. Till clause 4, if my counting is not wrong, this political party, original political party, has been used 8 times. 8 times. But there are many more. I'm just giving Lordship original political party, and sometimes they say political party in the same context. If your Lordship sees 1C without reading it, it's been read to your Lordship, but just keep it open with us. Then 2(1)A, and these are hard, these are the operative provisions. then explanation. So 1C, 21A, then explanation A. I'm sorry, my apology, was 21B also. 21B also. 21A and 21B. Then explanation A, explanation B, I, double I, actually much more than 8 actually. You have to look at the subclauses. Then 2 bracket 2, then 4 bracket I, and many times in clause 4. Now, Willis.
Interestingly, Dr. Singhvi, where does the expression original political party in 1C appear in the text of the 10th schedule?
Yes, yes.
Just as a matter of curiosity, I mean,
Yes.
nothing really would turn on this.
Well, it's when they say.
It's in 4. It's in 4. 4.
In the merger.
Where is original political party merges with another?
The political party phrase in the other clauses means the same thing. I'll tell you in a minute why. Because the idea, in a minute, I'll come to it. It's the same concept. Now, Willis, this is directly would be an issue on a subsequent date before the election commission, even on their reading of the symbols order. I'm not accepting the application, etc. All that is separate. On their reading, the symbols order clause.
Dr. Singhvi, can you just formulate the 4 elements and then you can
Yes.
because
So
this help us in.
Yes. Number 2 of the 4 elements, the first is political party, the second split group faction all out permanently from 2003 WEF 1104. Permanently out. That was the big bullet's pain because you created an anti-defection law. It was circumvented so easily. Therefore, and we have not yet read, Your Lordship, not hearing the matter. If Your Lordship reads the statement of objects, it's very crafty to prevent precisely what is happening now. So, element number 2 of the 10th schedule, no form of split group or faction. Because that is directly what the election commission has to do.
Right.
Directly. In a minute, I'll show you. Number 3.
Directly?
That is exactly what the election commission is asked to do in the symbols order.
Okay.
I'm just saying, Willis, it is suggested that Your Lordship is unrelated to issues. Hear this matter in November. Let the election commission go on. Because how unreal would that be? Kindly consider. How duplicative. How irreversible. Number 3. And the statement of objects when we come to the final hearing will show that. There is a necessary condition and then there is a sufficient condition in 10th schedule. It's a cumulative combination. Now it is common ground, I repeat, that the necessary condition may have happened, but the sufficient condition not alleged to have happened. What is the sufficient condition for this? You have to, inverted commas, not recognize, break away. And then, because now that there is no split, so more than 2/3 go. That means it's the new group. That group by itself makes no difference to the 10th schedule. Suppose, let me give an extreme case. Out of 100, 90 go. Or 75 go. Unless the second sufficient condition is cumulatively satisfied, that is irrelevant. That is the whole purpose of the amendment. They have to merge or declare by merger, create a new political party. But only merger is the sole defense. Just bear with me on clause 4 for a minute. Just this needs to be read. Clause 4. That was the whole idea of substituting merger for split. It is nobody's case that in whatever form Shiva Sena exists there, in our whatever factions, that it has merged with the BJP. Now, a member of a house shall not be disqualified under 2(1). That's the only defense. It's an exemption. You will not be disqualified if this happens. It's like an exemption. a member of a house shall not be disqualified under 2(1) where his original political party, the question Justice Chandra should ask, merges with another political party and he claims that he and any other members of his original political party have become members of such other political party, or as the case may be, of a new political party formed after such merger, or have not accepted the merger and opted to function as a separate group. This will be for the balance 25 or 10 in my example. Because you've gone 75 are gone, 10 are left, 25 are left. And
So the people who remain after a merger,
right.
their entitlement to be legislators is not taken away.
Because
You are entitled to say, I don't form a part of the merger. I stay back and I continue with my own.
I'm very grateful, Manas. I'm very grateful. Because, Manas, and quite rightly, it is not their fault. The remaining 10 can't be disqualified because 75 have gone with it. So that's a very logical. Now just continue the suffix. Suffix is important. And from the time of such merger, continues, such other political party or new political party or group as the case may be shall be deemed to be the political party to which he belongs for the purposes of sojourn. Now,
Deeming occurs subsequent. The deeming doesn't occur prior to that.
that's one of the important points of time. Absolutely right. So, Malas, merger is the only difference.
Yes.
Now, and may I state the fourth one and then I'll make my submission. The fourth element is the election commission in some form will be deciding a majority. I'm using the word largely and loosely. Majority. Now, my question to myself is, how does the election commission maintain a complaint by people who are not recognized under the defection law as a merged party? Number one.
Just a moment.
How do they enter the door of the election commission? Look at the irony here. This is very interesting political irony here, which I'll come to in a minute. You can't maintain my complaint because you asked me at the door, who are you? How have you come here? Second, the election commission will decide majority by persons who, if the proceed, you will be disqualified tomorrow. Well, can your lordship form any part of a majority if somebody is disqualified? You are deciding this bunch of people is disqualified or not. They will be the same people who will be the majority considered by the EC and will be subsequently held to be disqualified. Well, it is putting the cart before the horse. I don't understand why a constitution bench can't decide the basic issue and the election commission can wait. What is the value? What is the urgency? What is the balance of convenience? It is to make it irreversible. It is to make it a fait accompli. It is to then come and say, oh, there is the constitutional authority which has decided. Now what is left? That is the real purpose.
All right. Yes, you got your 4 points. Mr.
Now,
You go to the next point.
Just note for one thing. Well, if you are, what happens is there is a dilemma which is there. You have left the Shiv Sena, but you want to have the goodwill of the Shiv Sena. So you don't merge. And you merge and knock at the doors, you will be a new political party, subject to numbers. You want the best of both the worlds. Who are admittedly claiming that you are the Shiv Sena, which is a concept not recognized in the 10th schedule. Where is it recognized? Anywhere. And you want to yet call us a Shiv Sena and yet say that no, you can go. Well, in what form? This is driving a coach and four through this. And Wallace's fifth point is, this thing was enacted, Wallace, 15 years, 20 years after, on the Gayaram scourge, with a huge amount of discussion, and amended in 2003. We are talking of largely a procedural construct of a symbols order, how the election commission will proceed.
Dr. Singhvi, you're right. Dr. Singhvi, you're right that the 10th schedule does not recognize who is the real Now, who is the real party? Party A, you are the Shiv Sena.
Yes.
But is that a concept which is alien to the symbols order? No.
Well, it's-
The symbols order, who represents or who is the real party is not alien to the symbols order. You're right, because the 10th schedule is extremely tightly structured. The only defense is that of a merger. There is now no defense of a faction, of a split, of a one-third split. Yes.
One answer is that, assuming it is so, I'm not conceding that, I'm just answering my lot of two alternative points. That has to logically follow, not precede. It's the
See,
first
let me tell you what is really troubling is this.
Yes.
The whole concept of disqualification is in relation to the House.
Yes.
All right. The jurisdiction of the Election Commission is to decide who represents the political party, right? Which of various factions represent the political party. The Election Commission exercises superintendence and control over the elections under 324, Article 324. What happens on the floor of the House is a microcosm of the consequence of the holding of an election. Right? That, so that is an area where, there is a little bit of constitutional thought to be done.
Answer number one. The Election Commission has to look at the legislative and the non-legislative wings of the party, decided by your lordships repeatedly, including the famous case of Saranja. That's answer number one. Your lordship should not be under the impression.
So your contention is that therefore, your contention really is that because the legislative wing of the party is brought under a cloud by virtue of the disqualification proceedings, therefore the Election Commission is necessarily then to be stultified or to be interdicted from exercising its jurisdiction in regard to the non-legislative part of the party. That's an area which is a little bit of.
Well, I were to appear in the Election Commission in symbol order cases. What the issue?
Now compiling.
Just to give you
I just give one.
There are 3 or 4 answers. Just kindly take this common convenience compilation. This will solve a lot of problems. There is this volume I have taken out of this. Your lordships had them taken out. It's called common convenience volume. Just 2 or 3 pages.
The old one.
Old one. Common convenience volume. Old one.
ये क्या मेन पेपर बुक में है सर? हाँ.
Two or 3 things here.
What are you showing, Dr. Singh?
Yes. First,
So we don't get identical. What exactly are you showing?
I am showing, Willis, in that volume, common compilation volume, the Election Commission notice at 698, page number. 1 minute. Yes, sir.
What is the date of that?
Election Commission is dated
Page 1853.
22nd July 2022.
22nd
July 2022.
Dr. Singhvi, why don't you give us a PDF page?
That was meant for the main hearing, not for today. I should take a technical objection, but still that. Our training is still incomplete. That 22nd July. Now, will it?
1853. Incidentally, for the record, it is page 1853 of the PDF pages.
185. Yeah, great.
Dr. Singhvi, at 12 sharp, we'll wrap up with your side. We'll give you another 5 minutes, and
Yes,
so that
I'll be very.
we'll just take a short break, a comfort break, and we'll return to hear the arguments of the respondents after.
So, let me be very pointed. Now, this page, which your lordship has got the PDF of, the notice itself, as in all election matters, the symbol matters of the Election Commission. See the last page, 702. I'm sorry, I'm not able to assist. 3 pages later. The last but one paragraph.
1857.
Yes. Require, well, let's just see the top paragraph. Prior to the hearing of the 2 rival groups, if any, inter alia require both rival groups to submit their respective documentary evidence of support claimed by them in the organizational and legislative wings of the party. That phrase I'm asking Lordship to underline. Now, let's very quickly, if your Lordship doesn't mind, going back to my page 684, which should be was about 10 pages out here. PDF page, no PDF. My learned opponents for this filing in the EC is very revealing. What they file. That starts at my page 670.
Interestingly, both sides in their written submissions have referred to the pleadings of the other. What the other side, when you filed your pleadings, both of you didn't have an idea of this thing that is going to now happen here.
I have said anything very seriously wrong, but this is very interesting what they have said. Kindly see 684.
684.
Yes. It's para 23, small Roman 23. Yeah. It is submitted that the petitioner, now this is the petitioner, the other side, presently enjoys the support of 40 out of 55 MLAs of the Shiv Sena. This is directly another issue. There is no question of 40 out of 55 disqualified people. In the Maharashtra Assembly, a resolution dated 26th of June passed by 40 MLAs reaffirming their support and faith in the petitioner and the main leader is annexed. That's point.
But can the EC proceed on a demurrer that assuming that these 40 persons are not to be taken into account in determining who represents, which faction represents the Sena,
Then the petition
even so?
That petition can't be filed. So there's no such thing. The petition can't be filed because the approach is all details of organizational and legislative, and just these 2 pages later, 687.
687.
2 pages. Well, the filer, the approacher is Mr. Shinde. He is not a member of the Legislative Assembly. Is he not claiming on the basis of the legislative assembly status?
Right. Page 687.
Number 687, on the top fourth line, organizational and legislative wings of the party. Fourth line, para 9, on the top of the page. Then para 10, next para, fourth line, all layers of organization as well as legislation wings. I can multiply this now, my time is short, so please come to Sadiq Ali. The citation is 1972, volume 4 SCC, 1972, volume 4 SCC, 664. What document
Now, I think that is the
document my lord is reading has been filed by a sole person, Mr. Eknath Shinde, whose only status is that of a supposed MLA of the Shiv Sena, is what I will say. Now,
are you now reading Sadiq Ali?
Sadiq Ali, para
I think Sadiq Ali is part of the convenience compilation.
Yes, page 14 of their convenience compilation, the other side, but your lordship can get it in so many forms.
Just give us a moment.
Para 26 there is. As your lordship knows, this judgment has stood the test of time, even though it is
Election commission.
Yeah, I just saw it.
I'm great. Well, I am only on the point that there is a huge overlap, direct interconnection. Your lordship is decided.
Yes,
that's why I'm not concerned about the final merits. Your lordship is told that it's a North Pole, South Pole apart. It's two unrelated issues. That's what I'm objecting to. As if they're two unrelated issues. Now, just see what is in their complaint, in Mr. Shinde's status, in their pleadings, they say, I have so many MLAs, I have so many MLAs. Now read this judgment. An election commission says legislative organization. Now read the judgment, para 26.
Para 26.
26, which is at page 677. The figures found by the commission of the members of the two houses of parliament and of the state legislatures, as well as those of AICC members and delegates who supported Congress J, have not been shown to us to be incorrect. It is, in view of those figures, it can hardly be disputed that substantial majority of the members of the Congress in both its legislative wing as well as organizational wing supported by Congress J. That's why the same phrase is used in the notice of the election commission. Same phrase. As Congress is a democratic organization, the test of majority and numerical strength, in our opinion, is very valuable and relevant test. Then they go on. This is, of course, 68 is 15 years prior or 20 years prior to the judgment is prior, but I'm at the moment of the judgment's own terms. Can you separate? Can you are told that this is unrelated issue. Then also note para 29, the last 4 lines. majority of houses of parliament, and sum total of members of state legislature. Last two lines of para 29 to save time. Last two lines of para 29. In any case. Last two lines of 29.
In any case.
3 lines. Now this third aspect. Symbols order, which is very important to repeat, predates by 15, 20 years, 17 years, is premised upon not a disqualification situation. It is premised upon a dispute. Because we are one group, we have a fight. He says, I want the symbol, I say, I want the symbol. It never contemplated the penal consequence of him being disqualified or being disqualified. It did not even enter their mind.
Correct.
Therefore, this was premised on the legislative wing. The logically prior stage has to be the disqualification. That is logically prior. Number 4, Malas, your lordship uses this phrase, it has become a commonplace, but there's a lot of weight. Not when the Supreme Court uses the developer, even lower courts. What is the meaning of this subject to outcome? We just say it like that. Your lordship will find the iron, yes, your lordship says that. The idea is, look, I'm putting you on warning. You will claim equities because I may ultimately hold this way or that way. Now, this is the hiatus between them is several months.
All right, Dr. Singhvi, thanks. Can we wrap up on this?
Yes, I'm done with this. But I want to only say one thing, that your lordship will keep in mind also this concept of voluntarily gives up. Voluntarily gives up is a very important phrase, which your lordship finds in 2.1a, inter alia. How do you voluntarily give up? You voluntarily give up when you don't satisfy the conditions of a schedule. Suppose I expel you. Then, of course, you are not voluntarily giving. That's why I said, in the actual reality of political life, expulsion is welcome sometimes. It is a welcome. But if you do some activity which is subject to disqualification and you leave and you proclaim yourself as a separate group, but don't merge, you have voluntarily given up membership. But if you have given up membership, with greatest respect, how does para 15 apply? That too by the sole applicant before the Election Commission, Mr. Eknath Shinde. Who's the sole applicant? There is no other application. Today, Manas, your lordships can always decide, but today, Manas, he is under a cloud, under the simple text of 2.1a.
All right, Dr. Singhvi, thank you very much. We'll just take a short break and we'll be back and we'll hear these. Yeah.
Balance of convenience of lordship doesn't have any impression that your lordship has some imminence or urgency.
Mr. Sibal made the point. We saw the of those orders. We can just see those for a moment. That's all that we shared.
That's a different matter. The question is, it exists, is what I'm saying.
All right.
We direct, there are 3 enough. We direct the parties.
All right.
Thank you.
Yes, yes, Mr. Paul.
Because I very briefly, as VCA, what was the background which led to this litigation starting, and then come to the specific points raised by Dr. Singh and Mr. Singh. Because around the third week of
Mr. Paul, you appear for
Mr. Shinde and some of the legislators.
yes. Yeah.
That's around the third week of June 2022. A hopeless minority of MLAs within the Shiv Sena decided to convene a meeting, appoint a new whip, remove Mr. Shinde, which they had no authority to do because they did not represent the majority at all. The same day, coming to know of it, the majority of the MLAs met and immediately nullified the appointment of the whip they had appointed, the removal of Mr. Shinde, and overwhelming majority. But simultaneously, what they did was, a day later, they said that we had convened a meeting on 22nd of June 2022 at 5 p.m. And since these MLAs did not attend it, they are all disqualified. And we, on the same day at 5 p.m., are given a notice. In the meantime, this happened on the 22nd. Before that, on the 21st, the majority faction had already issued a notice for the removal of the deputy speaker. Which was pending. The deputy speaker, my lords, on 25th immediately gives a notice to our faction and says, give your reply against your disqualification because the allegation is you did not attend the meeting as convened, and because you have not attended the meeting, you stand disqualified under 10 schedule. And gives us 2 days to file our replies. Now, this comes to be challenged on 27th of June 2022. Wherein this honorable court says that as an interim measure, time is granted till 12th of July 2022 to file our replies. Immediately after that, MLA's leader of the opposition meets the governor and asks for a floor test. It is at that stage, and the governor issues a communication to the then chief minister, directing him to face a floor test on 30th of June 2022. A writ is filed by Mr. Prabhu, according to us, was illegally appointed as the whip by a minority of the members in the Supreme Court. A direct 32 saying that the governor should be directed not to whom?
A writ under Article 32 by Mr. Prabhu.
Yes, not.
He was a whip since 2019. So
Sorry, Mr. Prabhu?
He was a whip since 2019.
I said we had removed him, I had said.
Mr. Sunil Prabhu.
Yes, we had removed him on 21st of June. I had said so when I was giving my events. We had removed him and you had removed Mr. Shinde, which we said was a wrongful removal as minority evidence. That's what I said.
Where?
Now, my lords, so they find a
32 is by Mr. Prabhu.
That's saying that no floor test should be held.
Yes.
In view of the fact that disqualification of 42 MLAs is pending. Arguments for over 3 hours are held in the matter, and ultimately the court says that, look, in view of the law as laid down, as we cited, the court has said floor test, if at all, should be held at the earliest. And we said, why should you shy away from a floor test? You can't today say because a disqualification is pending, the floor test should not take place, because there are judgments of your lodges to say, even if a disqualification of an MLA is pending, he is allowed to vote in a trust vote, he is allowed to vote on a floor test, he is allowed to vote on the disqualification of a speaker on a deputy speaker. The proceedings and the function of the House cannot be stalled merely because the disqualification is pending. And those are your lordship's judgments on the point, on the issue swearing. And given the fact that floor test is the surest way to determine who actually enjoys the majority in the House, if at all a chief minister is confident enough, he should be more than eager to play the floor test rather than evade and escape and run away from a floor test. So the court said, and directly said, we do not find any ground to stay convening of the special session. Now, my lords, immediately after that order comes, on the very same day, that evening, when the order is pronounced,
What's the date of that order?
29th of June 2022.
Yes.
On the same day, Mr. Thackeray resigns as the chief minister. Mr. Shinde and Mr. Fadnavis approached the governor, stake a claim to form the government. Mr. Shinde is sworn in as the chief minister. Then after that, the speaker is appointed. The speaker proves it because they ultimately again challenge the speaker's again appointment and Mr. Shinde's appointment. The speaker is overwhelmingly voted and confidence is reposed. And these are the facts which ultimately led to their all-inclusive one petition which comes to be filed where this IA has. I'm running through some of the other facts which may not be so relevant. So that's the broad background in which they now come up with an all-encompassing writ petition, saying that the decision of the governor to call Mr. Shinde to be sworn in, the floor test, of course, had become infructuous by then because the earlier writ petition, the chief minister had resigned. Then they say the speaker's appointment, etc., all illegal, and the Supreme Court should decide all these issues. Even before the speaker decides these issues, all of these proceedings should be transferred to the Supreme Court and they should be decided. There is no mention in the prayer clause or the writ petition about the Election Commission. In fact, there are categorical pleadings in the writ petition that the issue of who is the Ship Sena is the exclusive domain of the Election Commission. This is their writ petition, where they say the decision as to who is the Ship Sena is the domain of the Election Commission. Now, after that, my lords, we approached the Election Commission. The Election Commission, looking at the nature of representation that we make, say that clearly there are MLAs on this side, there are MLAs on that side, there are representatives on this side, there are representatives on that side. So obviously a dispute has arisen. And issues them notice to come and file a reply, place the relevant documents before the Election Commission to take a considered decision in the matter.
Mr. Kaul, where did they make this categorical argument that decision should be of?
Yes. Page 8 of our convenience compilation, round D. That petition was filed on 8th of July 2022. But I'll come to the specifics later. So at that stage, when the election commission says, come and file the relevant documents before us, we have to proceed as a coordinate constitutional authority and exercise our jurisdiction to see who represents, because this is really an intra-party dispute. No one is saying, our case is not that we voluntarily given up the membership or we are splitting from the party. These are two rival factions within the party. So the court, so the EC said, we'll decide as to who represents the Shiv Sena. They come to the court and say, the EC should not be allowed to go ahead. The EC says, the Supreme Court says, we are giving you more time to go and seek time from the EC to file the documents. That request is again reiterated later, and the court again extends time to file documents before the EC. There is no order ever injuncted, and there was no notice issued in this IE to EC also. The order is go and seek more time to file documents. No injunction order ever passed. And ultimately, my lords, when your lordship passes the order of reference to a constitution bench, on the same day, an order is passed saying that the issue as raised in this IA will be considered by your lordships. So it is factually incorrect to say that on repeated orders of the Supreme Court, an injunction was being granted, or it was an understanding between the parties that the EC will not proceed with the matter.
Just give me the date on which the Election Commission issued the notice.
Yes, ma'am. 22nd of July, 22nd of July, 2022.
And what is the date of the order of the Supreme Court? No injunction, you said, but only time to file a...
Yes, yes. 4th August, it says, grants liberty to the petitioner to apply for extension of time before the Election Commission.
Yes.
Now, this is the background. And our respectful submission, of course, first is that this IA is beyond the writ petition itself. No substantive petition has been filed.
One short question. The letter of 1st of July 2022 issued by Shiv Sena Secretary for removal of R4, R10, R27 was made to the Election Commission. You will get it 360.
Yes.
So they wrote a letter to the Election Commission saying that we have removed them from the political party. Am I right?
Yes. And even earlier, in June, they had written a letter to the Election Commission informing that they had taken the decision there.
And not expelled from the party, removed from the post.
Correct.
Just not
removed from post.
Position. Removed from the position of
Thank
leader in the party setup.
My lord, so all that I'm saying is, and I'll now summarize what my points in the law is. The law today is laid down by your lordships on a number of these issues as sought to be now canvassed is no longer recent. One is, my lords, the lordships have categorically held that the jurisdiction of the speaker, when examined under the 10th schedule, is to exercise his power to determine disqualification in the House. The speaker cannot embark upon, those are the words used by the Supreme Court, the speaker cannot embark upon deciding a split or a merger within a political party. Secondly, what your lordships have held is that,
except with one caveat, Mr. Kaur, that the whole concept of a split now is alien to the 10th schedule. That's one. Therefore, the reason why the speaker can't decide as to whether there was a split is because the 10th schedule now obliterates this concept, effaces the concept of a split. On merger, perhaps you may not be right because merger is expressly a defense under the 10th schedule, under clause 4.
Oh.
Therefore, whether there has been a merger or otherwise may possibly fall within the ambit.
I'll show some of the other provisions also which
Right.
still be in the context of the legislature party, not the
That point you have made. That
My
is all
lord,
the concept.
my lord, your lordships were absolutely right in what your lordships are saying. My submission on merger is only that the speaker's jurisdiction is on the legislature part. That part of subclause 4 of 10th schedule was not read out to your lordships. I'll just read that. Secondly, my lords, your lordships have held that even where the symbols order does not predicate a particular situation or deal with a particular situation, the Election Commission of India, exercising its expansive and the words used up plenitude of plenary powers under Article 324 of the Constitution, is well within its rights to deal with any situation that arises. That is not to say for a minute that I am canvassing that under clause 15 or clause 18 of the symbols order, the Election Commission does not have the adequate power to deal with the situation like that. I'm going a step forward. Even in 15 and 18 were inadequate to deal with the situation that we are dealing with. Your lordships have said the plenary powers are enough for the Election Commission to deal with any such situation. But here, categorically, 15 deals with two rival factions within the party. And 18 covers situations which the Supreme Court has interpreted as interim directions or other orders which may be passed in the interest of justice. And your lordships in Sadiq Ali, while in detail dealing with the symbols order, categorically first dealt with the issue that a situation arises of two rival factions within a party. 15 is squarely the provision which sufficiently empowers the Election Commission of India to deal with it. And then Sadiq Ali proceeded to say that while considering it, both the legislative majority and the political majority will be looked at. But that is the Election Commission of India. A constitution bench of this court has already said that while the speaker decides the 10th issue, 10th schedule, jurisdiction of disqualification, he can't get into the political party because the very nature of the dispute is such, as my lords pointed out today at the start of the hearing, 1.5 lakh, 50 lakh representations by us. Zilla promotes, talukas, district officers. Evidence is there. The powers, as your lordship knows, have been vested on the power, and the Supreme Court has said powers of the state, powers of the court on the Election Commission of India. That is the alternative adjudicatory machinery created to deal with each of these issues.
Only thing, Mr. Paul, the genesis of the entire dispute, I think that's really the sense of the submission, that the genesis of the entire disputes arises from what happens on the floor of the House. Right? Absent what happens on the floor of the House, everything else wouldn't have taken place. That's their contention. Now, if that is so, then the issue as to what happens, the symbols order predates the 10th schedule. Sadiq Ali predates the 10th schedule, right? Because Sadiq Ali, in fact, Justice Hegde Grover and Justice Khanna.
That's
Now, Sadiq Ali predates the 10th schedule. Therefore, when Sadiq Ali speaks of the powers of the EC to determine both the legislative and the organizational majority, that the former part, namely its authority to decide the legislative majority, was at a time when the 10th schedule was not in operation. Now, does the fact that the determination of whether or not a disqualification has taken place is now exclusively entrusted to the Speaker, does that to that extent dilute the authority of the EC? And if so, then what is the impact of that decision which is entrusted to the Speaker? That is, I think, what they were really driving at.
So, Manoj, firstly, post Sadiq Ali also, and I'll show those judgments if there have been judgments.
No, we've seen those judgments which just formulate the point.
Post Sadiq Ali also, which have talked about the interplay of 10th schedule, symbols order. There is nothing to suggest. There is nothing to suggest that any way does the 10th schedule dilute the exercise of jurisdiction under the symbols order 1. We, my lords, the constitution bench of this court categorically says that when you embark upon this inquiry, it is restricted to majority in the House. Because the very nature of inquiry that we are talking about, where a political party is completely beyond the machinery provided for the Speaker or the powers vested in the Speaker. And that is why that whole line of judgments, my lord, where your lordship said powers of the state, powers of the court, all vested in the Election Commission of India. Detailed evidence. Now, will the Speaker get into interacting with every taluka pramukh, every district officer, every president of every area, the registered membership of the party? It doesn't get into all that. There is no machinery for it. That's not the intent. And if your lordship sees everywhere in the 10th schedule, political party in a context and then followed by legislature party, as your lordship pointed out, including clause 4 of 10th schedule. And it is interpreting that a constitution bench of this court says that when you embark upon the journey of deciding on disqualification from a house, don't mistake this for a power to decide the larger political issue or division in the political party, which is there. And I tell your lordship, inherently it can't be done by the Speaker. And there is nothing today in this matter, my lords, nothing at all as far as the pending petitions are concerned, whose outcome in any way will impact what is pending before the Election Commission of India. I take their case at the highest, that we will all be disqualified as members of the House. I take their case, that's the maximum that can happen, my lords, that we are disqualified as members of the House. Does that stop us? Does that stop us from going to the Election Commission as a member of a political party to claim that we represent or we are the Shiv Sena?
But suppose you were to argue on a demurrer, assume for a moment that the person who has moved the EC is disqualified. All right, for a moment on a demurrer. Does that disqualification of the person who has moved the EC impact upon either his locus or the authority of the EC to determine who really represents, which of the two factions represents the party?
So Manu, that's a very pertinent question. Let me So, my lords, the question that my lords put to me, let me give your lordships two stages which can happen. One is what is happening here, and the other is what your lordships put. One is that disqualification petitions are pending. The Supreme Court has told the Speaker on their request not to, in the meantime, take any decision on those because the Supreme Court was seized of the matter as far as the Speaker's exercise of jurisdiction is concerned. And pending those petitions for disqualification, can an MLA or an MP be prohibited from approaching the election commission? Your lordships in any number of judgments have said that even when disqualification petitions are pending, an MLA and an MP is well within his rights to participate on the proceedings of the House. Vote, exercise all that is vested in him under the Constitution.
So until he is disqualified, the consequences don't attach at all.
Absolutely,
That's the rationale for it.
One, and including my lords,
Yes.
including the line of reasoning that your lordships took
Yes.
in Nabam Revia, that
Yes.
that if a deputy speaker or a speaker of membership, that he can always proceed in a direction where his own disqualification, that was another lane, would be accordingly impacted. So till I am disqualified, I continue to be a member to participate all its vigor and robustness in the proceedings of the House.
At page 359, that very question. This is a letter written by Uddhav Thackeray to Eknath Shinde saying that you have been indulging in anti-party activities and have also voluntarily given up your membership in Shiv Sena. Therefore, in exercise of powers vested in me as the Shiv Sena Paksh Pramukh, I remove you from the post of Shiv Sena leader in the party organization. So this doesn't affect his primary membership. If his primary membership is actually affected, then he can't maintain a petition before the election commission. That's perhaps their argument.
Yes.
So therefore, at the threshold, election commission cannot maintain a petition on his behalf. But if it is not affecting the primary membership, it is only a post he continues to be a member of the political party, then he can perhaps file.
And my lord, just to add to what your lordships are saying, this is their contention that I have given up my whole cases. Who says I have given up the membership voluntarily?
That is yet to be considered.
That is yet to be considered. My whole case is that a set of 14 MLAs decide that I am removing something and overwhelming majority is on one side. You take a unilateral decision with a hopeless minority and then say, I've disqualified you or you voluntarily given up a membership. We have repeatedly said that we are the Shiv Sena, whether it's in the Lok Sabha or it's at the Legislative Assembly. We represent an overwhelming majority within the party. We've never said we've left the party or we need to merge with someone under 4 to be protected. We have right through said that whatever actions a set of people who were in a hopeless minority took have no sanctity of law, are unsupported by any legal provision at all, and you could not have done, you did it without authority. So with such emphaticness, when it is said that you voluntarily gave up the membership of the party, who will decide this? Because you say I've given up voluntarily the member under 10 schedule, or will the speaker decide it under the 10 schedule? Because your lordships have held that the power of the speaker and the decision of the speaker under clause 6 of the 10th schedule is final on these matters. And that decision is still pending. My lords, was the question that your lordships put to me, that suppose a person, now this is the first case where no decision has been taken, the issue is pending. The other is I am actually disqualified and I incur the wrath of Schedule 10 of the Constitution by whatever action there's a decision of the speaker against. That still does not, as my lord said, deny me the primary membership of the political party. I'm still entitled to approach the election commission for whatever grievances I may
that you have said, so that you are not removed as a member of
Yes.
the party. You may be removed, disqualified as a member of the legislative party.
And now, my lords, they sought to rely on Sadiq Ali to say that, look, both the words legislative and organizational majority have been referred to in Sadiq Ali. Now, organizational and legislative majority is referred to in Sadiq Ali from the perspective of the EC deciding, not from the perspective of the speaker embarking on an inquiry as to who represents a majority in the political party. Then they relied, my lords, on to say that this will have a bearing on the matter because a judgment of this court said, and I'll read out in what context the judgment was when I come to the case law, to say that any disqualification ex post facto relates back to the date when you were disqualified. And thus, if they were disqualified on that date, that's the end of the matter. Quite apart from the fact that even if I was disqualified, it doesn't stop me from going to the EC. But the reason the Supreme Court said ex post facto, and there are other paras that I need to show, was this, because that was a case of a BSP government in Uttar Pradesh. A decision was taken to dissolve the assembly. The cabinet decision was yet to be communicated. I'm just very briefly giving. 13 MLAs of the BSP went to the Samajwadi Party and said, stake a claim to form the government. Because these 13 MLAs went to the Samajwadi side to stake a government, Mr. Maurya at that stage made a petition to the speaker saying that this is an overt act on part of 13 MLAs to show that they have voluntarily given up the membership of the party and thus they ought to be disqualified. So the speaker was seized of this issue of disqualification of MLAs as on that date because 13 MLAs had gone to the Samajwadi Party side. In the meantime, another 24 MLAs joined the 13 MLAs and they claimed that there has been a split in the party. Now the speaker went ahead and decided the issue of a legitimate slip with 24 joining 13 and did not decide the issue of disqualification, which Mr. Maurya prior in time had directed, saying that your very act of going and seeking support from the Samajwadi Party amounts to giving up an anti-party activity, voluntarily giving up membership. In that context, the Supreme Court said, as far as exercise of powers by the speaker is concerned, this disqualification will relate back to the date when the speaker was required to exercise the jurisdiction and the speaker could not have decided on the split within a party without deciding their original disqualification from the House, which stood there. It is in that context that the word ex post facto was used. And I'll show those two specific paras. The same judgment, my lords, the Supreme Court then goes on to say that you as the speaker can't embark upon and decide within a political party what happens. Your lens is only the lens of a legislature party that you have to see it. And inherently, my lord, the proposition which is sought to be forwarded will be impossible to implement. A, the Constitution doesn't say so. B, practically and inherently, it's impossible if you expect the speaker to get into these issues of lakhs and lakhs of memberships across the country without the necessary adjudicatory machinery.
So according to you, both the powers are different. Jurisdiction under both the powers are different. And the inquiry under both are different.
Completely different. If at all, my lords,